Every day in the USA, people find themselves in court.
Court calls the case of River Ridge versus Timothy Kelly.
Rachel Dornbush, Your Honor, on behalf of the plaintiff.
Your name, sir?
Timothy Kelly.
I have two motions up. I have your motion to set aside the default.
Put the picture of my daughter here. She's an occupant. She wanted to be here to say something, but she was in school.
Okay.
Thank you.
No, sir, that picture is not going to happen that way. You're not going to sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kelly.
Okay. Come on. Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in. Girls, I mean the nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have them.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right. I thought they were both sent because I have a double thing where you could send group, and I sent them. At any rate.
Okay. All right.
Your Honor, I just, with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And, that's why I know I missed the trial, but there's all kinds of reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
I have read everything that comes in this.
All right. I didn't know. I'm just, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant-landlord disputes. That a judge could take a proactive role in the hearing by ensuring that both parties know.
What are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing, all the legal stuff that I read is that you try and work it out before the eviction case. And also I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up because.
Sir, you know what?
What? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Do not.
The Mitchell.
Do not come here.
What?
At this hour, questioning me.
I'm not
about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here, they've been here, and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor, please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're gonna have a problem. Will you throw something down again, we're gonna have a problem.
Sorry, Your Honor.
Case of Spice Street Apartments versus Haley Salsbury. And Gavin Westland. Haley.
For the record,
Hello.
Rachel Dornbush, Pallets Law on behalf of plaintiff, Your Honor.
All right, you were to make some decisions. What are we doing?
Well, let me just start, Your
Go
Honor,
ahead.
by just saying we're prepared to dismiss this case. My client has received the escrow check. Miss Salisbury's rent is paid in full and then some. And so I don't know that the exact dollar amount will get her through December because the water sewer charge isn't exact, but it should be pretty close. And then I believe following this, Miss Salisbury and property manager can discuss her options going forward and what her intentions are now that everything's caught up.
That's your understanding, young lady? Okay. All right, then what I'm gonna do, I'm gonna dismiss this case.
So just to catch everybody up, so the GoFundMe went through. There was some tribulation about how much money the facility was going to withdraw from the escrow because they had enough money to pay off the whole year. But there were some thoughts that maybe Haley didn't really want to stay at that location for the rest of the year. Her whole thinking is, if they want me gone, I just want to leave. So what's happened now is they've paid through the end of the year, not all the way through till next summer. And she has the option to leave if she wants to leave. So everything is fully in her hands moving forward.
All right. That's without prejudice. I'm gonna order that the trust balance be refunded to the defendant in this case. Well, specifically to you. Okay. So since we have two defendants on here, Miss, well then, can we make sure that they're clear? I'm gonna put it in the file that it will be to Haley. That being defendant one.
Yeah, it's posted correctly, so.
It's posted to, it's posted to her, so if I just tell them to refund it, they'll only give it to her. All right. Haley, good luck to you.
Thank you.
Uh,
Do I go over there to the clerk
And get a check?
and ask them, or
Sure, you can ask them. They're probably not gonna, they're
yeah.
not gonna write you out a check today, but
Is that how it works though, or do I need to do anything?
yeah, they'll either give you a check or mail it out to her, right?
They will mail it.
Okay.
They'll probably cut it sometime next week.
Next week, and they'll mail it to you, okay?
Mhm.
It's good.
Mhm.
Haley, do me a favor. Take care of yourself, please.
I will.
All right, be happy, and always realize that with all the dark things and everything that happen in the world, that there comes a point where sometimes good things can happen, and you just never give up faith. All right,
Okay, thank you.
take care.
You too.
Retry this. Court recalls the case of River Ridge versus Timothy Kelly. This is your motion to set aside the default judgment. There are
Yes.
two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you, for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with a friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child. I don't want to put it on record yet because has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And I've
Your Honor,
met.
I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that conversation happened.
I thought at that time that it was
I'm not going back over this.
Your Honor, if you would listen if I could cross-examine witnesses and bring my witnesses in, you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, you know, but it was a good reason. I want you to know the facts of the case. That's
The
all.
second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Kelly.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, you know, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, you know, and they're all filled up. I think it's hard to even express because I'm afraid I'll offend you, and
Sir, do not try to blame me
I'm not blaming
for
you
this.
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me,
no,
somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well, I had all kinds of things written down. I started to read it, and you said, "Don't read that to me." Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going
It
to
doesn't
fill
work
out.
that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial. The plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog. So she's added on without. So I'm just confused about the way to present evidence, I guess. She brought up my daughter missing a day of school. Where did that come from? I mean, all
I
of
didn't
those have been.
mention his daughter at all, Your Honor. I'm sorry. When
It's
did
in
I
the
mention his daughter?
it's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what
Sir,
happened there.
I need meritorious defenses you have to this claim.
You can't tell me what. May I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
I don't
And- Your Honor, Mr. Kelly is retrieving his phone. I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious. Could you spell it for me?
No.
Okay. See.
You
Oh,
filed the motion.
Yeah, probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay, suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well,
I have no idea.
is
what
it
that means.
moratorium? I'm sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay, can't. No, I was gonna make. I think you should stay too. Go ahead.
When I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court, or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have arisen. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we do not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. If you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I will allow it to happen because I'm probably one of the most unfair judges I've ever met, but I'm going to try to be fair. Mr. Kelly, can I step away from the podium?
May I give you a compliment, please, Your Honor?
No,
okay.
Do not give me a compliment. Do not say anything to me at this
All
time.
right.
I'm going to handle Mr. Fink's case as Ms. Dornbush. Sooner or later, you'll be able to go home.
Okay.
She's going to be mad at me.
I would never dare.
I tried. River Ridge versus Timothy Kelly. If Ms. Dornbush.
I am still here, Judge. Yeah.
I've called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I I put in one of my letters that, or one of my motions that somewhere there's a phone call of that because it was a three-way conversation and I didn't know if I needed to look it up or not, but as far as the upon information belief and all those lists, please, I deny them and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it on the grass, but that was during the settlement conference. What I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates because the car wasn't running but it had legal plates up until that point. So that's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornberg, your response.
Thank you.
Oh,
Your
I'm
Honor.
sorry, I don't have.
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
Thank you.
Okay.
Your Honor, at the outset, when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay. And that's not something my client is going to agree to. And I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well, because I do have his email address.
Okay, yes. Well, you have the court's permission to do that, understanding what you just
I don't have a problem.
Thank you, Your Honor. The specific issues that he put in that I believe have absolutely no relevance to the issue of good cause is that the court being aware of his transportation issue and is having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up and he chose not to take the ride because of another reason, and we'll touch on that in a moment. But he had a ride lined up and he has a ride today, I believe. My client's here and sees that there's another resident in the community that she believes may have driven Mr. Kelly to court today. So clearly he has the ability to get transportation here. As the court noted, Mr. Kelly didn't call the court. And Mr. Kelly made a statement that his phone was broken. But Your Honor, I seem to recall, and maybe I misheard, but in this hearing, when questioned about why he didn't call the court, he said he didn't have a phone. But just a minute before that, didn't he say that his daughter called him about an emergency?
The night
So
before.
daughter was able to call him the night before. If his phone was broken for the 3 or 4 days before that, somehow he didn't have a phone the morning of court to call. But not only that, he's obviously got people in the community that are there to support him. As the court pointed out, he could have borrowed a phone from anybody. So I don't believe that Mr. Kelly has stated good cause. For the additional reasons stated in my motion, Your Honor, he stated his belief that he'd be given a break because default was a possibility, may enter. But Your Honor, Mr. Kelly's been in court before and failed to appear, and a default judgment was entered against him. And I referenced that particular case number in my response. Your Honor, he referenced his concern related to his alleged request for a jury trial, but the court has already touched on that. And Your Honor, the date, just for the record, that that particular issue was addressed was September 20th of this year. He cites an alleged case with the Michigan Civil Liberties Department, and I assume he means the Michigan Department of Civil Rights when he states that. Again, has no bearing on his good cause for appearing at the trial date. That he was finally in touch with an attorney from MI Legal Help. Again, no bearing on his good cause for failure to appear, and that he intends to file appellate pleadings. Again, no good cause for his failure to appear. Your Honor, this emergency with his daughter, I'm sympathetic to whatever's going on in his family situation, but Your Honor, Mr. Kelly has been stating various times throughout these proceedings that this alleged custody issue has interfered or detracted from his ability to meaningfully engage in this court process. And Your Honor, I personally did a search of the Circuit County Register of Actions. I don't see anything pending in that case. My understanding from what's available on that Register of Actions is that Mr. Kelly's ex-wife has sole legal custody of his daughter. And one of the police reports that we were able to obtain from the Michigan State Police, and I believe it's from sometime last year, I don't have the exact date, that there has been no change in that. They specifically referenced that his ex-wife has custody, full legal custody of his daughter, and that there's been no change to that. If there's been some change between 2023 and now, Your Honor, it's not showing on the Register of Actions, but there's nothing pending showing in that case with the Washtenaw County Circuit Court. Your Honor, with respect to this alleged meritorious defense, first off, we've already addressed at the settlement conference before Mr. Kelly was taken into custody for that bench warrant, why additional things were added and more specifically stated in our complaint for termination of tenancy. And that is because the demand that was issued, Your Honor, states reserves the right to bring this and other issues that are least violations to proceed on the termination action. And so at that court date, Your Honor, which was approximately 3 weeks ago, Mr. Kelly had notice of what additional grounds would be relied upon by plaintiff. One of those issues was an actual admission by Mr. Kelly with a photo he provided to the court of his dog sitting outside on a tie out. Community doesn't allow that. And frankly, Your Honor, the dog was tied out again today. Mr. Kelly nowhere in sight. My client is signed into Zoom right here, and she could tell the court that, again, the dog was tied out. Mr. Kelly was not out there with him. Minor violation of the rules, Your Honor, yes, but it's just a continuation of Mr. Kelly believing the rules don't apply to him, Your Honor. And that's unfortunately been how this process has gone throughout. Every time the court has ordered Mr. Kelly to do something and he didn't follow through, there's just been some reason why he should be given leeway and that he shouldn't be bound by the orders of this court, the rules of the community, the laws of the state of Michigan, Your Honor. Speaking of those laws, Mr. Kelly has still yet to state any defense to his driving in the community, probably since 2017, without a license. The lease that he signed clearly states he is to be in compliance with the laws of the state, local ordinance, federal law. And Mr. Kelly is in violation of Michigan state law by driving without a license in the community. He's been living there since 2017, and I believe he acknowledged at the settlement conference on the 22nd of October that he hasn't had a license since 2017. So that on its own is sufficient grounds for this court to grant a judgment of possession. And I believe Your Honor even alluded to that at the last court date and still gave Mr. Kelly the courtesy of having an opportunity to appear for a bench trial and bring his witnesses. With respect to this alleged retaliation or retaliatory eviction, Your Honor, the statute is very clear on what constitutes retaliation, and Mr. Kelly has yet to cite anything in that statute that my client, that he has done that would bring about a claim of retaliation by my client. But even if he had, Judge, that is a rebuttable presumption. And my client would still have the ability to show that they have legitimate grounds to terminate Mr. Kelly's tenancy. Your Honor, at that settlement conference, it was discussed how Mr. Kelly's answer was deficient for a number of reasons. One of those things being that he in no way addressed the specific issues that were referenced in the termination of tenancy notice, that being the animal loose in the community, disturbing other residents, parking on the lawn, failure to maintain the home and site, verbally abusive towards management. He's addressed a few of those things today, Your Honor, and my client would acknowledge today that certain issues with respect to violations relating to condition of the site were addressed. But as we discussed at length at the October 22nd hearing, Your Honor, with respect to the vehicle, it's sat there for months after violations. And Mr. Kelly didn't do anything about it. My client had to ultimately have the vehicle towed. So there's a violation right there that there's clearly no defense to. With respect to the verbal abuse of management, Your Honor, how do you cure that? You can't go back and take the words back. I mean, it happened. So that's not really a curable thing. With respect to disturbing other residents, that's something that continues to happen.
That's not true. I mean, that's just a statement.
Mr. Kelly, I didn't interrupt you.
Oh, I'm sorry. I
I'm
can't
not-
talk. I thought you were done.
you'll
I'm
have an-
sorry.
You will have an opportunity
sorry.
to respond. But Your Honor,
Okay.
we talked at length on October 22nd about how Mr. Kelly's answer was deficient because it didn't address those things. And in filing his motion, Your Honor, he still doesn't address those things. The only things that he brings up is this alleged audio recording that he thinks will prove retaliation. But that's not going to be sufficient. The statement that he's provided does not give any detail, which is the issue that was precisely stated at the hearing on the 22nd, and Mr. Kelly is still not following the rules and now expects the court to give him leeway again. The court has already done that by setting the matter for a bench trial on the 30th. Mr. Kelly's own motion, Your Honor, clearly states, I made the decision not to come to court because I didn't want to bring my daughter. He made a calculated decision based on the circumstances not to come to court. And he has not set forth anything in his motion that should change that outcome, respectfully, Your Honor. And so I have to ask that this court deny his motion and allow the judgment to stand.
Your Honor, I want to address the motion itself. She had brought in I meant to put that under the ex parte where I marked the money to go into escrow.
But there was no escrow filed.
No, there wasn't, but there was a box. Your Honor, when I was before you, it was, you know that I have money problems. I have a fixed income coming in every month. And when that comes in, I can pay any arrearage. I mean, and that's what I was speaking to when I met the demands, when only in the money, I wasn't talking about here, but when I went before you, I've been going before you for the last 4 or 5 months before the just cause. And what I was saying was that, you know, when you said pay on this date and the court said we did, except the one time when I was $43 short, which she'll probably bring up. And regarding the settlement agreement, I was going through these. In fact, I was on the car on the lawn discussing it and speaking to you, Your Honor, when you discovered the warrant thing, and then I was taken out. And when I came back, we didn't discuss anymore. So, I mean, I don't know how I can address it better than that. We were addressing it and going down the list, but then I didn't you know, I didn't get to, but you know, it's kind of hard and I'm trying to follow her. You know, some of these things, she says that I don't, in my answer, I don't explain things. It's kind of general. Well, not, this stuff doesn't either. It just says that, you know, she's stating that the abuse and threatening of staff, I have yet to hear, what are you talking about? I mean, I can throw out, we can all throw out things out there, but what did I say? Who did I say it to? You know, what was it? Because I can remember that conversation and the incident because that coincides with the electricity, the electrical cord. So, I mean, I mean, these are kind of vague too. I don't know how to defend them, but there is the reason there's a civil right, and I did put the letters wrong, but as far as the Michigan Department of Civil Rights, that I do have a case number or a complaint number, and that's for the very reason that I've been trying to explain to you about the differences in her, you know, her writing me up, or the, you know, the landlord or the property manager writing me up and not writing the neighbor up for the exact same thing. I mean, that's listed in discrimination by the state of Michigan. I read it and it uses an example like that. Like if you have a resident here or a tenant here that is late for their rent, and you go in and make a move on them, but across the street is the same exact thing. They're late on rent, but you don't there. That's a civil infraction from what I've read, or it's discrimination. And that's what's going on here. That's why I kind of brought in, you know, sent those pictures to you. I mean, and as far as the day I missed, that was a terrible week when it was my responsibility. I say that in my motion that I got cuffed and thrown in jail. But, you know, I get home and I'm on this website that I've never seen before. My daughter brings it in and it's you, and it says contemptuous defendant goes out the back door. And gosh, the comments were brutal. I mean, brutal. It's not up anymore, but it was. And my daughter actually answered to some of it. So that week was just brutal. But I said that about my daughter because and the neighbor that drove me here, he's left, so I'm stranded again. But he will attest that we were ready to. He was my ride. He usually is, and his car's in the driveway right now. It broke down, and I did try to get other rides, but everybody's at work at that time of day. So what I meant in that was I did have my daughter. If I do get a ride, I got to take her. I wonder if
you said you had made a decision not to.
Well, only because I didn't know if it was allowed at the court.
No. You're telling me you had this and this is what you would have done. But your motion says you had made a decision because of your daughter not to come to court. You can't have it both ways.
No, I know. I explained before that what I was going to bring her, Your Honor. That's what that meant. But I said I don't want to make you mad again because I didn't know if minors were allowed in here. I mean, it explains that before that. I mean, she wants to, you know, she's 13. She wanted to make a statement to you about it because it's kind of her house. But that's not what I meant by it. I take her everywhere since she was born. I have no qualms bringing her, but I meant that because I tried to find rides. We couldn't find a ride with the neighbors. They were all at work. John's the only one that can give me one. Car still broke down in the driveway, Your Honor.
Your Honor, may I respond?
Go.
Please.
Keep going, Mr. Kelly, whatever you want to say. I mean,
I can tell you where it's going, and I'm not an expert.
You can't tell anything about it.
Okay, maybe you're right. I'm sorry. But this is very tough to just present it in a professional way and say it as I mean, but that's honest. I mean, I was trying to get a ride here, but that was the final decision so I don't get a babysitter for her and go hitchhike down Michigan. I just said, since she's here, you know, that was just meant that I made that decision after I couldn't find a ride. But I mean, I haven't skipped your court dates. I'm looking to save my house. I mean, and it's not necessarily to stay there, Your Honor.
Mr. Kelly, I'm going to stop you because
Okay. May I say,
you just sat here, tried to tell me some story about that you were going to appear. I'm going right to what you filed with this court.
okay,
I have good cause for my failure to appear. I did not appear / answer because, I did not go to the court because I had an emergency hearing regarding my 13-year-old daughter the night before. Says nothing about you actually bringing her. Says nothing about her coming to the court as though you just represented to the court. You didn't come because of her. I'm done.
I don't have it by
done.
memory.
I'm so done.
Please, Your Honor, I just want to.
Mr. Kelly.
You're gonna tow my house away with all my possessions? Not you.
Mr. Kelly, I'm going to follow the law. I've listened to you all day and you keep going back and forth in some of these things. But I'm ready to rule. I've listened to the plaintiff. I've listened to you.
Please give me a trial, Your Honor. Please.
Mr. Kelly, I gave a trial date for the parties to be here. It should be noted, although plaintiff didn't say much about it, plaintiff was here with all of their witnesses waiting for you to appear. Everybody interrupted their day.
I know.
They were here ready to go and you didn't appear. And quite frankly, from the court's perspective, the court doesn't hear from you for a good 9-10 days after the trial date. Don't hear anything about what happened, this, that, nothing.
Sorry, Your Honor.
No, you don't have to be sorry. I'm just saying, you're distorting what has transpired. Plaintiff was here, ready to go, ready to, I'm presuming, state with specificity, have testimony and evidence regarding every one of their allegations. You do not appear. Your notion that you've been following the direction of the court, not true. I had to beg you to get an answer into me. I finally got that to happen, told you to pay escrow, you didn't do it, and then still didn't comply with the escrow issue. You may have your reasons, but don't say you followed the direction of the court when you didn't, and you know you haven't.
I guess I tried my best.
You know what,
sorry.
Mr. Kelly, I have listened to you all day.
Right.
Now is my turn. I do not want to be interrupted. So for the reasons, part of the reasons regarding your, as I've indicated, there are two prongs you have to satisfy. One is you had good cause for not appearing. You have by no means established that you had any good cause whatsoever from appearing on that date. Now, you make it sound regarding your arrest on the bench warrant as though somehow or another you were manhandled, put in jail, locked in a cell, way down. Let's be real about what happened. You got locked up because there was a valid bench warrant out of 14A4 district court. My court, but handled by another judge. That judge, as I told you, happened to be here that day. We took you into custody. I spoke with her to make a determination as to what to do. And one thing you never said about it, ever, because you're just trying to create sympathy, is you were released that same day. Told what your trial date was, told everything, and you were released without having to post. In fact, when you came back, I arraigned you on the bench warrant and gave you the date to go appear for your driving while license suspended. So don't make it seem like somehow or another this evil judge all of a sudden locked you up on a driving while license suspended and just left you sitting in jail, and that because of that you could barely get yourself out of jail and then appear for trial. That's not what happened. Do not interrupt. And then you sit here with these meritorious defenses or whatever you're trying to claim are defenses. I agree with plaintiff. You have not established any of those defenses, particularly the one you keep trying to harp on, which is the retaliatory conviction. There's a predicate before you can even allege that. You've not even gotten there. Nothing you've alleged is even close. So you don't even have to go through a further analysis of it. You haven't started that type of action against the plaintiff. You've not stated it and haven't shown anything regarding that. The cold-hearted reality regarding the meritorious defenses is, and this is just the reality of how it works, plaintiff would have to just show one, and it could lead to your termination of your tenancy. When you place yourself in this position, you have to show me a meritorious defense to all of their claims. You failed to do that. I honestly don't believe that you've established even one, but you certainly have not established any defense whatsoever to any of these claims. I'm done. You just haven't established. And so for those reasons, your motion to set aside the default judgment is denied. The court specifically finding that good cause nor meritorious defense has been established. The judgment will stand, the writ of restitution will issue. Because the writ of restitution is issued and there hasn't been a written answer filed to the motion to remove the manufactured home and the time has passed, the court will also sign that order and grant that plaintiff's motion regarding that. I am.
All my
Thank you.
stuff's in there, Your Honor. All my daughter's stuff, the neighbor's stuff. And my equity in the home. I want to say thank you that day. I did say thank you. It's on the record for you letting me go home that day I was caught. I was very grateful for it, so.
Your Honor, I believe I submitted proposed orders for both, an order denying
Yes.
attendance and a motion, and an order granting our motion.
And I have signed that order. I have signed the writ, and I have signed your order regarding the removal of home.
Thank you, Your Honor.